I'm Dan Covington. I'm going to talk to you about why a trust is better than a will, and primarily about why it is that you want to avoid probate. You know, trusts can reduce costs after death. Probate is going to involve court costs, publications, attorney fees, and sometimes executor compensation. Many folks just decide to avoid these costs by signing a living trust. Trust administration is faster than probate, of course. I can't say that across the board 100% of the time, but it tends to be true in a vast majority. For instance, a probate case is going to very commonly run at least 6 months and thousands of dollars, where trust administration is far, far quicker and more inexpensive. Trustee can distribute trust assets fairly quickly. The executor in probate, however, has to follow a number of notice procedures, publication, waiting periods for creditors, due process considerations, which present opportunities for all sorts of interested parties to object before the court can approve passing assets of the decedent. One you don't hear much about why a trust is better than a will's incapacity during life. If something should happen to you that you need some help or some care during your life, your trust can really do more than a durable power of attorney. Power of attorney is important, but a trust can, while it can give someone authority to help you out, a trust is also going to set out parameters within which you'd like this to occur. And very importantly, a trust is going to be there to provide assets for this to happen, right? Another way trusts are better than wills. Contests are not encouraged by trusts. Probate, by its due process-oriented nature, provides built-in invitations to challenge the will, to object who may control the estate, appointment of the executor, for instance, object to the size and the type of the ultimate distributions from the estate. Trusts, on the other hand, don't carry the same burdens of administration. While there's a built-in accountability, of course, for the fiduciaries and to require that the trustees act in accord with the provisions of the trust, distributions can be made which are plainly within the terms of the trust document. Another reason a trust is better: if you have real estate in more than one state, with a will, you're going to have to, Kansas anyway, with a will you're going to have to probate, at least do some abbreviated probate proceeding in the second state. With a trust, that's not necessary. Then there's business succession, or swift business succession. In a probate case, let's say someone passes away owning a business, and they're the point person in that business. The business may need to retool, to change management, to realign how or what it's marketing, or just liquidate quickly. In a probate case, for the reasons you've heard, that's not terribly likely to be able to happen quickly. With a trust, it's kind of a simple procedure. The trustee has authority to make those changes. Finally and ultimately, a trust can just be easier on your family. You've already avoided the probate. Many people are simply of the mind that they like to know that the bulk of their estate plan work and the succession is already handled. They put in a little work now, and it's simply easier on their family, who has fewer hassles when they're gone. So this is just a handful of reasons. Trusts are, in my mind, across the board, generally superior to wills and to dealing with probate. I'm Dan Covington. You can always find me at Estate Plan Kansas.